Hello, everyone. We are starting with the session Enforcement of Arbitral Awards in India. This is one of the most interesting and critical area of arbitration law. The session is hosted by Khaitan and Company. I'm privileged to introduce the esteemed speakers for this session. Our first speaker is Mr. Gaurav Joshi. He's a well-renowned senior advocate with 30 years of rich experience in litigation and arbitration. Next on panel, Mr. Nicholas Lingard. He's a partner with Freshfields. Nicholas represents both investors and states in treaty arbitration cases around Asia and the world. He represents clients in commercial and construction disputes across the industries. Moving on to our next speaker, Mr. Sanjeev Kapoor. He is senior partner with the dispute resolution practice of Khaitan and Company, New Delhi. Sanjeev has diverse experience of over 23 years in litigation and arbitration, including treaty arbitration. He is one of the popular arbitration practitioners in India. Next on panel, Mr. Vivek Gambhir. Mr. Gambhir holds legal qualification in India and in England. He was an advocate on record in the Supreme Court of India before joining CMS. He's presently General Counsel Corporate with Abu Dhabi National Energy Company. It's my pleasure to introduce an AOR, myself being an AOR. Our fifth speaker is Mr. Raj Panchmatia. Raj is partner with dispute resolution practice of Khaitan and Company, Mumbai. While Raj has rich experience in commercial litigation and arbitration, his dynamic personality. Raj will be moderating today's session. I welcome you all on behalf of MCIA. The present session is being transcribed as well. Over to you, Raj.
Thank you, Surjendu, for the kind introduction. And welcome everybody, and thank you for joining us for this session on enforcement of arbitral awards in India, which is hosted by Khaitan and Company at the India ADR Week, which is a first-in-kind initiative taken by the MCIA, and I hope that this will continue, and we will do this every year again and again. Thank you, MCIA, for organizing this. As you know, today we live in a globalized economy. There are cross-border transactions, multiple parties getting into contracts in different jurisdictions. That would automatically also involve disputes between parties and cross-border disputes coming in. What people look at is arbitration as a natural choice to resolve their disputes in international trade and commerce. And when we talk about international arbitration, once we have the award, the natural progression is towards enforcing that award. Today, we will discuss what are the issues faced while enforcing those awards and what we should keep in mind so that the least amount of issues are faced at the time of enforcing those awards in India. As you know, for enforcement of award, there is the New York Convention of 1956, which has gone a long way in enforcing international awards across India and across multiple countries. There are around 170 signatories to the New York Convention, but just being a signatory to New York Convention doesn't make everything. What is also important is that even if an award is passed from a New York Convention country, a signatory country, it needs to, and where you are looking to enforce it, that country also needs to have ratified it if there is a provision for or requirement of ratification between the two countries. So if India has ratified a New York Convention with a particular country, which is from where the award is coming in, it becomes that much more easier. Therefore, it is important that ratification is also done before enforcement of the foreign awards. India has ratified around 45, notified around 45 countries with whom it has a reciprocating arrangement for enforcement of awards. Of course, the numbers need to go up much more, considering that there are 170 countries who are signatories to the New York Convention, and India's only got 45 with whom we have a treaty, we have a notification. Having said that, we are hoping that government will notify more countries in the near future. Today, to discuss all of this, as you rightly know, we have an eminent set of panelists who will help us dissect this entire issue and give us a great insight on what we should keep in mind while enforcing these awards into India. Thank you, all of you, for joining us today. For housekeeping, I just wanted to tell you all that, we will be immediately after this putting up two questions on poll. We will request you to please answer those questions. That will help us put this, give a perspective to this entire discussion. So therefore, I'll request MCIA to put the polls up. Okay, can we get the results of the poll? Okay, so we have around 40% people who have experience in enforcing awards in India, and 60% have not. And most of them feel that enforcing an award in India takes around 1 to 3 years. Around 60% of people feel that. 20% feel between 3 to 5 years. 18% feel more than 5 years. Thank you. This is going to be very helpful for us to set our session going forward. With this, I'll straight away come to our panelists. Let me first come to you, Gaurav. We've always heard and seen that enforcing an award is always far more challenging. What are some of the reasons why enforcing foreign awards in India can sometimes be time-consuming affair? Is there anything a party can do to reduce these timelines?
Yeah. Before I answer the question, I must thank Surjendu for the kind introduction, and also thank MCIA and Khaitan and company for inviting me here. Now, what are the reasons why it can be time consuming? The principal reason is that there is a heavy backlog of cases in court. So it takes time in court, takes time to process and have the applications heard. Now, given that there is this backlog, what can be done to expedite the process? Now, there are two ways we can look at it. You can anticipate the grounds of challenge, which are generally under Section 48 for resisting enforcement. And you can take steps prior to the award being passed and subsequent to the award being passed. Now, as far as steps to be taken by a party is concerned prior to the award being passed, what basically has to be done is you will have basically two types of arbitrations, contested and non-contested. A non-contested arbitration where an ex-party award is passed, it may be easier to get the award, but then it becomes open to challenge, particularly if proper notice is not given or ample opportunity is not been given to the other party to appear. So there you must ensure that ample opportunity and notice is given to the other party to appear. And then if they choose not to appear, of course, they bear the risk. So that is for as far as contested awards are concerned, if a party is indulging in dilatory tactics, of course, you have to be firm, but still not rigid, if I may say so. And what I mean by that is repeated applications for adjournments, of course, would be refused. But if there are some genuine grounds for adjournment, then you should not be too rigid about it, for the simple reason that it opens up a ground for resisting the award on the ground that he did not have an ample opportunity, no proper notice was given, or he was unable to present his case. Similarly, insofar as evidence is concerned, of course, you must go by the rules. If the rules provide for oral evidence, you should allow that. These are all grounds which are something which you can anticipate, knowing that this party will once again seek to resist the enforcement of the award once the award is filed in India for enforcement. So these are some of the grounds. Of course, it's also in the hands of the arbitrator, and the arbitrator should also necessarily follow the due process and should not be in a haste to pass the award. Now, as far as steps which we can take after the award is filed, first, you must ensure that all procedural compliances after the award is passed. You must ensure when you file the enforcement petition that all procedural compliances are in place. You don't want technical grounds like the copy of the award is not available or a certified copy is not there, which are grounds which would, I mean, ultimately curable grounds, but it would delay the process. The other way I look at it is, given the backlog of cases in India and the difficulty of getting the cases, particularly in Mumbai and other cities, placed on board for a expeditious hearing, if possible, and if the grounds so justified, if you can move for some interim reliefs or attachment of properties, etc., then you do get priority because you move for urgent reliefs. Your matter is heard in that sense for urgent reliefs in priority. And at that stage, if the judge is impressed, the judge may decide to dispose of the matter itself. So these are some of the broad grounds which I feel you can reduce the delays which take place in enforcement of awards.
Thank you, Gaurav. Nicholas, if I may come to you now as an international lawyer who regularly advises clients on India-related disputes. What has your experience been with enforcing foreign awards in India? And how long have the timelines been in your cases?
Thank you, Raj, for the question. Hello, everybody. My thanks too for the organisers. I'm delighted to be here. I might begin by saying I was very disappointed that us panelists were not able to participate in the earlier polls, which could have been the simplest answer to your question, which I promise I will come on to with answers from my experience in terms of timing. I want to make two general observations at the outset, though. The first is my experience now in advising typically foreign clients in connection with India-related arbitral awards and enforcement in India is that they will get the right answer. Their awards ultimately will be enforced if they are awards that should be enforced. But the note of caution is that it will still take a long time, and I'll come back and try to put a bit more meat on the bones of what a long time means. The second general observation I thought I would make at the outset is my experience is, and I'm keen to hear from the other panelists whether this resonates, my experience has been very divergent depending on in which court, in which part of the country one finds oneself. And perhaps we can come back to that in more detail as we proceed, but my experience has been very diverse across the country. To give an example, in one case in which I have had involvement over the past years, our client found itself seeking to enforce an award before a high court in India. Obviously, I was not counsel in the enforcement effort, though had been involved in earlier stages in the proceeding and watched the enforcement with great interest. And perhaps what was most interesting to me in that case was the case sat at the High Court level for some 5 years, ultimately leading to a judgment wholly in favour of our client enforcing its award. That quickly was appealed to the Supreme Court. And what was most interesting to me was that the Supreme Court dismissed the appeal very rapidly within 3 months of its getting there, which I think is an example of the first point with which I opened, that is getting to the right answer. And particularly my impression, if I may say so from a distance, is once one accedes the Indian court hierarchy, it is certainly the case that one is more likely to get the right answer. I wanted to make one final point, is this: our focus today is on enforcement, and the anecdote I just offered is about enforcement. There is often a further step, of course, and that is execution, and that can introduce its own complexities and a further timescale. I have seen with my clients that take several further years, particularly if execution requires, for example, the public auction of the asset in question in order to enforce by way of execution, which I understand, though everyone else on this panel is better qualified to speak to this than me, I understand is the case for some asset types in accordance with the Code of Civil Procedure in India. So there's an enforcement phase, potentially several years, and thereafter potentially an execution phase of which we ought not lose sight.
Thank you, Nicholas. It was very, very helpful. And as you rightly said, enforcement is one step, execution is one more. And it can really delay things in India at the time of execution as well, because there are a lot of requirements that need to be complied with at the time of execution. So yes, it is extremely important. Sanjeev, let me come to you. When clients come to you for enforcement of awards, what would they keep in mind? What should they keep in mind? What are the requirements for enforcing a foreign award in India? What evidence is required to be submitted to an Indian court for enforcing a foreign award?
Thank you, Raj, and good afternoon, everybody. I would say, and as you have pointed out, in India, the position is slightly peculiar in the sense that we are part of the New York Convention, but obviously we had an additional requirement that in addition to being a part of New York Convention, you also require reciprocating arrangement with the other party. So I think one of the very basic things, obviously, which you will test is that whether this is an award which is enforceable in India under the Arbitration and Conciliation Act. Is it an award which has been passed in a jurisdiction which is a convention country and with which India has got a reciprocating arrangement? Because obviously the options you will choose for enforcement would be entirely different for two sets. So I think that would be the very basic things which you would be doing. Then obviously and as Nick pointed out, we have got a large country and obviously so many high courts. There are certain experiences of some high courts moving very fast, some high courts moving not at that pace, some having more commercial maturity, let's put it, than maybe some other courts wherein commercial matters are not that prevalent. So I think other thing which you will obviously like to test is that there would be multiple options which might be available to a party in a given circumstances to file for enforcement of the award. And you would like to pick up the right kind of an high court so that all the relevant factors are taken into the considerations and you are making right kind of a choice. And as have been the experiences, that is a crucial and a critical choice in many cases. Coming to second part of your question, I think as far as the formality which is required or the evidence which is required, I think it's very informal. The Arbitration and Conciliation Act essentially requires two things. One is you need to file the award either in original or an authenticated copy. Second is you need to file the arbitration agreement, either original or an authenticated copy. In case it is an award which is in a language which is different than English language, then you file a translated copy of the same, which is duly authenticated. So I think those are the basic kind of an evidences which you would require. And courts have been quite liberal. If you look at the language of the act, the language says that these documents are required, shall be filed along with the application for enforcement. But Supreme Court of India has taken a liberal view. And in fact, Supreme Court of India has said that even if they are not filed at the first instance along with the application for enforcement of law, then also the application would not be dismissed as non-maintainable and it can be filed at a later stage. So I think the formalities and the procedures are quite simple when you go in for the purposes of enforcement of the award. But depending upon how it is challenged and what basis it's challenged, obviously it might need to elaborate it upon, and maybe the evidence which has been led before the arbitral tribunal might require to be placed before the court.
Yeah. So Sanjeev, I may just ask you one more question here at this time, because you mentioned the right court it should go to. So let me ask you, which is the appropriate forum for filing an application for enforcement of a foreign award? Because I remember there is a lot of jurisprudence on this issue as well, and we've seen certain some cases on the definition and interpretation on court which you need to go for enforcement. What is your view on this?
Yeah, so I think there was a confusion, and obviously different courts have taken different kind of positions, etc. Fortunately for us, I think in 2018, the Supreme Court of India has in Sundaram Finance case settled this particular issue. And essentially what Supreme Court of India has said that, and it's a very pro-arbitration kind of judgment, which essentially says that you can file in for enforcement wherein the assets of the party are situated. So obviously, in addition to the definition which is already there in the Arbitration and Conciliation Act, which says that you can go before the High Court where in case it was not an arbitration but a civil suit, you would have filed the suit. I think in addition to that, I think the canvas is now slightly more broader, because even if you have got assets also, there also you can file. Though the Sundaram Finance is in a domestic arbitration under Section 36, but obviously 2(1)(e) definition of the code and explanation of 47 is quite similar. So I would say that this would be something which would be very, very much applicable to it. So you would have various options which would be always available to you, and you might be able to pick and choose which might be the right kind of a option for you to file for the enforcement, and then obviously follow it up with the execution, though both are considered to be integrated by many of the judgments of the Indian courts.
So at this stage, can I just take one of the audience questions, and maybe Nicholas, if you would want to answer that. The question is, could the panel elaborate how an award holder can seek asset-related discovery and trace the debtor's assets during the enforcement stage?
I'm certainly happy to give it a go, Raj. Thank you. Perhaps I can take the asset tracing point, and then I will defer, if I may, to Sanjeev and others on the legal question in India of whether discovery is available, as it is certainly, for example, in a jurisdiction where I practice, New York, one can obtain discovery in support of an enforcement action. I'd be keen to hear from the Indian lawyers the extent to which that is available in India. Tracing in the enforcement stage, though, is a commercial activity, the same as it is at any other point in a dispute process, perhaps one you've begun before even arbitration proceedings are on foot, working with expert asset tracers to locate assets. So that may very well be an important part of the process. Let me pass back, though, if I may, Raj, on the legal question, where I fear I would not be on the firmest footing among my colleagues on this panel.
Any thoughts from others? Sanjeev, Gaurav, Vivek?
Just to add, Raj, I think in India also you can go to the court where you file for enforcement and execution of the award, and you can seek a direction from the court to seek an affidavit to be filed before the court detailing the assets of the judgment debtor in that particular sense. So I think that you can do your inquiries on the basis of which obviously you can file it, but obviously you can also seek the assistance of the court and seek an affidavit of the assets and properties, etc., to be filed by the party also before.
Raj, under the CPC, under Order 21, Rule 41, in execution proceedings, you can call upon the judgment debtor to disclose its assets. So you can file an application. Whether you'll get interim reliefs before your award is recognized as enforceable is a matter of argument. But if you can show some urgency and some apprehension that the judgment debtor is likely to dispose of his assets, and probably even at that stage, you can get an order for disclosure. So it's very often done. It's an order which is quite regularly passed. Of course, in that case, if you're not aware of what assets the judgment debtor has, then the court you would go to for enforcement is where the judgment debtor is located. Otherwise, you would end up in a court which would otherwise be without jurisdiction if he says, I have no assets in this jurisdiction. So you go to a court where he is located, where he has, if it's a company, a registered office or some other office, if it's an individual where he resides or carries on business. And from that court, you would have to then move for under the provisions of the CPC for interim reliefs or final reliefs for disclosure.
Vivek, any practical experience on this?
I think from my point of view, obviously I defer to the experts on Indian law. From my point of view, there are two issues. I think the first issue is that there is still some clarity required in terms of enforcing foreign awards, whether it has to be at a place where the assets are or where the judgment debtor is, or whether it can be at a place, as is suggested by the wording of the clause, that where a suit would have otherwise lay. Part of the justification for an approach, broader approach, is that a foreign party may not necessarily know, and this was the previous question, as to where the assets are. And therefore, this is not execution, this is enforcement. For execution, you need to go where the assets are, because otherwise there is no execution possible. So there is some debate in my experience that is still to be decided on that question. But I have to say that getting a disclosure on assets, the courts are rather proactive. they do give due credence to the fact that there is a award debtor against them in front of them, and the assets must be disclosed, and they do go for that. And in my experience, they are pro awarding interim reliefs to make sure that the award debtor doesn't use the opportunity of that exercise to siphon away the assets.
Thank you, Vivek. Gaurav, so you may come to you with another question on what are the grounds for enforcement, refusing enforcement of an award in India? What do you think are other than the grounds on which the courts are normally refusing enforcements in India?
Yeah, now the law, I think, on that has been settled by the latest Supreme Court judgment in Vijay Karya. Of course, the grounds are there in Section 48 of the Arbitration Act. But the judgment of the Supreme Court explains in detail exactly how you have to categorize the grounds, which grounds are mandatory and which are discretionary as far as the court is concerned. So it's basically divided into 3 categories of grounds. 1 are jurisdictional grounds, 2 is party-related grounds, and 3 is the ground of public policy, which is the ground which is generally open to the most debate. Now, as far as jurisdictional grounds are concerned, which are held to be mandatory and not discretionary, if the arbitrator had no jurisdiction or it was a dispute which was not arbitrable, then of course the award would not be enforced in India. And it's something which the Supreme Court says it's not open for the court in which the application is filed to enforce such an award. It's a ground which is held to be mandatory for refusing enforcement. Then there are party-related grounds. Party-related grounds are that you did not get proper notice, you were unable to present your case. Now, these are grounds which the court has said is discretionary because a party can, by its conduct, waive the question of getting notice. It can be a question of unable to present a case is very often cited as a ground that I did not get an opportunity, the arbitrator did not give me enough time. The Supreme Court is categoric that if you have failed to comply with the procedural orders of the arbitrator, then you cannot raise this ground. That means the arbitrator did give you time if you could not comply. So that's then it's something which it's discretionary and the court can say, yes, sorry, I will not refuse to enforce the award. I will enforce the award, in fact. I will exercise my discretion not to allow, not to reject or to refuse the award, enforcement of the award. The third ground is the ground of public policy. That has, of course, been explained by the amendment in 2015 following Renu Sagar. Renu Sagar said it is a very, very limited or narrow ground. That ground has now been explained as it should be contrary to public policy, means contrary to the fundamental policy of Indian law, something which is basic to Indian law and which you have ignored, or your award is contrary to that, contrary to principles of morality and justice. And it is now categorical, and it says so in the Act itself that you will not review the award on merits. You're not required to review the award on merits. So ex face, you look at the award and you find something which shocks your conscience and you think this is contrary to the basic principles of Indian law, then probably you can refuse the award, but not on a analytical thinking and analytical analysis of the award and deciding what is the merits of the case and whether the decision would be right or wrong. So these are the few limited restricted grounds. The Supreme Court also says that this is a watertight compartment. Whatever the grounds which are there in 48 are watertight. You cannot expand the grounds and come up with new grounds which probably patent illegality and all, which are grounds which are available for challenging domestic awards between domestic parties. So those are grounds which are available there, which are not available while refusing enforcement of the award. So this is the broad overview of what are the grounds available for refusing enforcement.
Thank you, Gaurav. Sanjeev, at this point, can I also trouble you a little bit and say your thoughts on will an award that deals with allegations of fraud affect its enforcement in India?
Very, very interesting issue, Raj, and I think some kind of an innovation has always been done to challenge the award on these grounds. Many a time you will see that there are cases which have been made out on misrepresentation, deceit, civil deceit, etc. in the course of the pleadings of the parties. And when it comes to the enforcement, then many times the ground is taken. But this award involves questions of fraud. Questions of fraud cannot be gone into by an arbitral, and therefore this award cannot be enforced. And I think Supreme Court grappled with this issue quite a number of times, but I think the clarity which has come recently, and I think I would say that it's quite a pro-arbitration kind of an approach which they have adopted. They have said that except for cases involving serious allegations of fraud, all other issues are arbitrable. It's only the cases which are involving serious allegations of fraud which are required, which cannot be arbitrated. But in case these are very peripheral issues of fraud, etc., or some kind of an allegation which is made, etc., those are not really taking away any kind of jurisdiction as far as an arbitral tribunal is concerned, merely because word fraud has been mentioned 7 times in the pleading or 20 times in the pleading doesn't say that obviously how could have an arbitral tribunal gone into. But still, serious allegation of fraud is also a very amorphous kind of a term, and it gives quite a lot of kind of a leeway to the court which is enforcing to the award to go into the facts and see as to what is serious, what is not serious, what is peripheral, what is incidental, etc. But fortunately for us, I think Supreme Court had the occasion to consider all this and earlier law which has been there in this particular domain. And they came out with this judgment. It's Arbitral. It came in October 2020. And therein, I think they laid down very robust principles on the basis of which you can decide what a fraud is or what not a fraud is. And essentially, if you call out 2 principles which the Supreme Court has said are the principles which we say are fraud, which are not arbitrable, and for which you will have to go to civil courts or for criminal authorities. They say essentially one is that in case the fraud is of a nature which goes to the very fundamental of the arbitration agreement, that is to say the arbitration agreement itself would not have been existed in case the fraud was discovered. So I think that's one test which has been said by them. The other test which is there is that they bring in an element of public I would say, if they say that in case your disputes are merely disputes which are contractual or inter se the parties, then obviously they really don't have larger public implications, etc. And therefore, those are issues which can definitely be arbitrated. However, they say that in case there are allegations of mala fide, fraudulent conduct, etc., against public instrumentalities, state authorities, etc., then that brings in some kind of a public element. And those are obviously the kind of cases which shouldn't be decided in arbitration, which are kind of decided by the courts or by the criminal authorities who are dispensing justice in that kind of field, etc. So slowly and slowly, if you see, the gate is getting tightened. There was no clarity as to what fraud would be, what fraud would not be. Then it came to a situation when they said serious allegations of fraud. Now they are identifying what a serious allegation of fraud is, and wherein obviously there are very serious public law elements which are involved, or it goes to the very root of the agreement itself, and they are going to interfere, etc. So to say that fraud can never be a ground for challenge of an arbitration, I think that's not really the case. But fraud can be now a ground of challenge of enforcement of an arbitration award in very, very limited kind of circumstances wherein the criteria which are in this arbitral judgment of Supreme Court are being met, etc.
So the egregious nature of fraud, if you are able to establish, then you will be able to put it up for challenge. And that's what I kind of gather.
Slightly, maybe more than that. That it goes to the very root of
Absolutely.
The agreement itself, and every agreement would be vitiated for the act of the fraud. So it's a slightly higher bar than I think. So they are putting in degrees of fraud also.
Very well.
A fraud might be very serious, but then it has to meet a threshold which the Supreme Court is saying.
So Nicholas, now I'm going to come to you. It's a question which is of a lot of interest presently in India. and there's a great deal of interest in emergency arbitrations, and there are a lot of queries that clients have, especially in wake of Amazon and future dispute, which has been all around making headlines in the press as well. So we have seen many institutions generally have emergency arbitration clauses, and so can you give us a brief understanding of what an emergency arbitration provisions are, and and how effective are they?
Of course, and thank you for the question. Perhaps I can begin with seeking to contextualize the question. What is the objective of interim relief, regardless of the forum to which one goes to seek it? Well, it typically is to preserve the status quo. What does that mean in practice? That might mean, and we can come on to speak about Amazon by way of example, that might mean preventing a party from dealing in shares that are the subject of a corporate dispute. It might mean ordering perishable goods. There's one case in Singapore involving coal sitting off the coast of China, ordering that those perishable goods can be sold pending the resolution of the dispute, because otherwise they will perish. It might mean an order that a party not call on a bank guarantee before the dispute is resolved. So it is relief of an interim nature, typically designed to preserve the status quo or react to an emergency situation. Now, I said there's a debate as to the fora to which one might go. Your question is targeted at one of three options, namely an emergency arbitrator. But by way of context, let us not forget that a party might also go to the arbitral tribunal once it is constituted. Now, it typically, as we all know, takes some time for an arbitral tribunal to be constituted. So the question is, what do you do before that? Emergency arbitrator is one option. To round out the options, though, the third is to go to a court of competent jurisdiction. I say of competent jurisdiction advisedly. That might be the location of the respondent. It might be the location of the assets. It also might be the court at the seat of arbitration. But let me come, having set that scene squarely to emergency arbitrators. They really are a product of the last decade or so, and as you rightly say, exist in most institutional rules, including here in Singapore in the SIAC rules, in the ICC rules, and in several others. They are designed to produce a result of the sort I set out at the outset of my answer quickly. So to speak of the SIAC rules, for example, once a party seeks an emergency arbitration, the SIAC is obliged to appoint the emergency arbitrator within 1 day. She is then obliged to establish a procedural schedule within 2 days after being appointed, and to make a decision within 14 days of being appointed. The only data set that's been published from the SIAC, though, suggests that most emergency arbitrators, in fact, decide much faster than that. Most decide within 2 to 3 days of being appointed, issuing orders of the sort I have said, do not deal in these shares pending the resolution of the substantive dispute. What does the emergency arbitrator issue? Well, she issues an order. It is clear in Singapore that it is not an award. And again, I will defer to others, but I understand that is similarly clear in India, that it is not an award. So what good is it? At least here in Singapore, the law is clear that it is enforceable with the leave of the High Court as though it were an order of Singapore's High Court, a provision that I understand closely reflects Section 17(2) of India's Arbitration and Conciliation Act, providing that an interim order of an arbitral tribunal can be enforced as though it were an order of a court, which begs the question to which we can come as to whether the emergency arbitrator is in fact an arbitral tribunal. And let me offer just a Singapore answer to that question. In Singapore, that answer has been made clear by a now relatively old amendment to the International Arbitration Act, which provides expressly that an emergency arbitrator is in fact an arbitral tribunal for all purposes of the Act. Perhaps I will pause there.
That was exactly going to be my next question, which you just answered. Whether the emergency arbitrator will be treated as a tribunal. But thank you for that clarification. Gaurav, what is your thought? And we've seen Amazon dispute going on in relation to this as well. Will India, do you treat that as an emergency arbitrators award as an award from a tribunal? And are such awards enforceable in India?
So let's appreciate one thing, that the Amazon case was a case of a domestic arbitration. It was an arbitration, though under the SEAC rules, it was an arbitration where the place of arbitration was to be in India. So in view of that, part 1 of the Arbitration Act and Conciliation Act applies. Now, given that, the question which was there in the Amazon case is whether it is an arbitral tribunal at all. Does the Indian law recognize an emergency arbitrator to be an arbitrator who can pass an interim order or award or whatever it is? Obviously, he can't pass an award. He can only pass interim orders, as Nicholas clarified. The Delhi High Court, in its judgment, took the view that on the grounds of party autonomy and recognizing that various institutions have similar provisions, that the parties could always agree to a procedure for appointment of an arbitrator, which would probably include the appointment of an emergency arbitrator who has a very limited jurisdiction over a very limited duration of time. They took the view, and that is the moot question which is now pending in appeal, is that it is an arbitral tribunal. Once it is an arbitral tribunal, the award becomes enforceable, the order becomes enforceable under section 17(2), given that it is a domestic arbitration. Now the question arises, what happens in a foreign arbitration? Arbitration not located within India. In that case, of course, the rules and the laws of the foreign country would apply insofar as procedure is concerned, and recognition of whether an emergency arbitrator is an arbitrator under their laws. Of course, it all depends on the terms of the contract, whether the contract makes Indian law applicable, foreign law applicable. All those are interesting issues which have to be considered. The question then arises, how do you enforce whether an interim order of an arbitrator, whether an emergency arbitrator or a regular arbitral tribunal, which is passed abroad? How do you enforce that order in India? Because 17 does not apply to foreign arbitrations. Part 1 of the Indian Arbitration Act only applies to domestic arbitrations, except to the extent of certain provisions which are made applicable to international commercial arbitrations where the place of arbitration is outside India, which is section 9, 27 and part of 37. Given that limitation, the probable remedy is that you would have to move under section 9. And that was recognized in the Balco case also. And therefore, thereafter, there was an amendment to the Act that for how do you enforce orders in India in respect of arbitrations which are situated outside India. And the court legislature having recognized this and recognizing the need for it has made section 9 applicable. And section 9, as you know, is a section for approaching the court for interim reliefs. So in such a case, probably the way out is that you would have to approach the court for interim reliefs. Now, in such a case, what the court would consider is again a moot question, whether it would consider the controversy, dehorse the orders passed by the arbitrator and consider it again on merits, or whether it would recognize the fact and accept that the arbitrator has taken a particular view which has to be given credence to. Of course, the courts are not going to be bound by the view of the arbitrator, but it can always recognize the fact that the arbitrator has taken the view, has applied his mind, and that the court in such circumstances has very limited scope of review in that sense and would then enforce the order of the arbitrator. So these are all moot questions. These are questions which are developing over a period of time, including this Amazon case, which is an interesting case, which is going to find its way, I'm sure, all the way up to the Supreme Court.
Sanjeev, Vivek, any comments, thoughts on this?
I say, as Gaurav has indicated, I think law is clear on two aspects. Obviously, is that if foreign interim order, I would say award would be a different connotation because award would be deciding a question finally. But if for an interim order, I think the judgment, in case you are successful, that has been the judgments. In case you are successful, then that's enforceable by filing a Section 9 in India. And obviously, what an interim order says would be of a persuasive value to an Indian court. It's not that Indian court is bound by, or it becomes an executive court for that. But law also has been that in case you have gone to an arbitral tribunal, tried for an interim order, and failed in that, then there are judgments of the Supreme Court which have said that you can't have, so to say, the second bite at the cherry. And then you can't come to India after having made that election of going before the arbitral tribunal out here, come and file a Section 9 saying, but in Section 9, you always have to consider the issue de hos of what the arbitral tribunal has said, and therefore please allow me to file it again. So I think generally the approach of the courts have been quite collaborative. They are trying and giving an avenue. The lacuna in that is that a foreign interim order cannot be enforced in India. But I think that lacuna has been tried to be closed by the court by making the Section 9 remedy applicable as a way of having that interim order enforced in India by filing a new Section 9. But I think courts have also been conscious that it doesn't become a kind of a second bite at the cherry, that you lose before the foreign interim tribunal and then you file a Section 9 and for India. So I think it's a kind of cautious approach which has been adopted by the court, filling the lacuna which is there in the legislature as far as enforcement of interim orders which have been passed by foreign tribunals is concerned.
I think if I can just add 2 sentences to that,
Sure.
From a perspective of a beneficiary or otherwise of an interim award, I think unless the law was absolutely clear and given the urgency of obtaining an interim relief, I think I would look at very carefully the option of actually trying to do it straight in India, for example, or the jurisdiction where the assets were, because if you're going to spend a lot of time in trying to convince the court that it should recognize either an interim order passed by a foreign court or an emergency order passed by an emergency arbitrator, you can sort of tend to lose the very benefit of getting an interim order quickly. So I think it would be something that I would look personally very closely as the option. And intuitively, until the law is well settled, it seems to me that the option of trying to get an interim award from interim order from a court in India would be top on the list, because I think generally speaking, the courts do favor preserving the status quo. It's not as if there is a greater advantage in trying to get an order from outside, which would then persuade an Indian court in case it was otherwise not going to get persuaded. So that would be from the point of view of a litigant. That's how I would look at it.
Thank you. I think you made my life easy. I was going to ask you the same question, that what would be your choice as an in-house counsel? So Vivek, let me come back to you with another question at this juncture. As an in-house lawyer, you have had an occasion to file interim reliefs pending enforcement of awards in various matters. What has been your experience like? Have you been able to get anything in the sense? Have you able to get a restraining orders or kind of an attachment orders even pending execution?
That's for me, Raj?
That's for you, Vivek. Yeah.
I think my experience in this regard has been favorable. I think and this I think is just reflective of the fact that there is a great deal of understanding about the seriousness that needs to be attached to a foreign award. I think the courts are getting much more are giving due weight to the fact that there is an award that has been passed by, particularly where the awards are coming from well-recognized institutions. I think they do that, and they do give due weight to it and quickly deal with that subject matter of passing an interim relief. However, whether that, I think the interim relief sometimes can be a good spur to getting, as I think Gaurav was trying to indicate earlier, could be a spur to getting the whole dispute resolved, provided that interim order bites the other party. I think if the interim order doesn't bite the other party in the sense that they don't have plans to sell their assets in any case, getting that order may not necessarily achieve that second objective, because part of the objective of getting an interim order is also to put pressure on the party to try and with the award debtor to resolve that. So I think my experience has generally been quite favorable in India. I digress a little bit here, Raj, but I do want to share a couple of thoughts on enforcement generally, if I may. I'll not take too much time. And just my sort of experience. I think there are two dimensions that I wish to share. One is that enforcement should probably be thought of right from the time you start the arbitration. Not necessarily something you look at once you get the award. And the second aspect of that is that it is not just the litigant or the parties who need to think about it. But I think if, as an arbitrator who's interested in getting the award upheld, it is also very important to bear in mind as to what kind of challenges and try to cover those areas to avoid those challenges being made, particularly on the grounds of natural justice or opportunity not being given, or making sure that the public policy grounds are, wherever applicable, are properly addressed. There's one more element which influences the enforcement, is that in a foreign award, you can obviously challenge the award at the seat of arbitration. Now, typically when one party does that, it tries to put a spoke in the enforcement using that. So that is something which you need to plan for and bear in mind, that is a process or a step that you have to go through in case the party chooses to, and award debtors might choose to do that. I didn't want to interrupt earlier, but I just wanted to place.
No, I think it's a very interesting point that you raised, that, you need to think of enforcement even prior to the award and at the time of arbitration. And maybe I may take that liberty to say that you may probably also want to consider it even at the time of drafting of the arbitration clause itself, as to where you're going to enforce an award, because depending upon that, you may also want to choose your seat accordingly. But it's a very interesting, but very interesting observations, Vivek. Sanjeev, may I quickly ask you one very nuanced thing which people have been normally asking? Does India recognize partial awards? And if so, how can they be enforced? Maybe in a couple of minutes.
Interesting question, I think, and there's quite a lot of confusion around what is an interim order and what is an partial award in that particular sense. Because from an enforceability, it makes quite a lot of difference. So during the pendency of arbitration, any order which is passed by arbitral tribunal would be of an interim nature, but those can be the orders. One is that an issue in arbitration is finally disposed of, or it's just an interim arrangement, and obviously that will get subsumed when the final award is passed. So there can be two kinds of an order which can obviously be passed during the pendency of arbitration. The kind of awards which can be passed, which will finally dispose of an issue, which can be decided finally in arbitration, are something which is called partial awards. Indian Arbitration and Conciliation Act does not define what is a partial award, what is a final award, etc. The only reference which you will find to that is in 21C, wherein they say arbitral award includes an interim award, and 31.6, wherein they say that whatever can be disposed finally by final award by an arbitral tribunal can also be disposed of in the interim finally by that particular tribunal. So I think we have dwelled upon this particular thing, that if it's an interim order, that is to say, it's not finally disposing of the issue, it's kind of an interim arrangement during the pendency of the arbitration agreement, which is agreed between the parties, then I think Gaurav has elaborated that, and the remedy would be that it would not be straight away enforceable in India, but you will have to file a Section 9, and then in that particular case. But the situation is different, because in case it's an award which is disposing of an issue finally, then obviously that would be treated as an award which can be enforced straight away in Indian Arbitration and Conciliation Act. But the test would be that it has to meet the other parameters which are there of the award. It has to be a reasoned award. It has to be properly signed by the parties, adequate opportunity, a particular case. If it is disposing of an issue finally, and the final award could be passed independent of this issue, which is getting decided by the arbitral tribunal, then that is something which is very much enforceable in India, as any award would be enforceable in India.
Thank you, Sanjeev. Now that brings me to maybe our final question, and Gaurav, if I may come to you for that. Is the judgment of Supreme Court in NAFED versus Elementa a cause of concern in the context of an award being against the public policy of India, or would the judgment in Vijay Karya overcome this decision?
The judgment in Vijay Karya is a very detailed judgment, and it sets out in detail exactly as to what public policy is, defines it, and says that it is ultimately, when you talk about fundamental principles of Indian law, you're looking at the basic Indian laws against which the award should be something which violates the basic Indian laws. Now, the law which is set out in NAFED is really no different. It says the same thing. It refers to Renu Sagar, it refers to the subsequent judgments, and reiterates the position that the concept of public policy is very narrow. However, in the facts of that case, it goes on to hold that where some exports are barred by the government, and the party could not legally make those exports. And there was also an arbitration, there was also a clause in the contract which postulated that. It goes on to hold that such a matter pertains to a fundamental policy of India. Now, it is debatable whether a government order which bars exports could be said to be something which is the fundamental policy of India, but the judgment does hold that. So it is really, in that context, restricted to the facts of that case. And particularly, if you see the judgment, I quite see the point of view of the Supreme Court judges, because the facts were quite glaring and jarring. And sometimes it's often said that bad facts make bad law. But here, luckily, the law is exactly what is the law in Vijay Karya. Maybe not in as much detail, but it is that law. The facts were such that where a party was under a disability to export, because the government prohibited the export, could it be penalized for being in default of the contract when the contract itself postulated that? Now, one point of view could be that this is a decision on merits, which you are barred from looking into. And the judgment does go in detail into the merits of the case, which is something which Section 48 now says, and the explanation says you can't go into. Or is it something where a party is prohibited by law from carrying out its obligations, where there is frustration and therefore the contract to that limited extent becomes void? Could it be said to be contrary to the fundamental policy of India? And that's the view which was taken, that it is contrary to the fundamental policy of India. It was a contingent contract, had become void in view of the order of the government. So as far as I see, as far as the law is concerned, according to me, there's no cause for concern. There is really no cause for concern. In any case, Vijay Karya explains in detail all the basic principles. Vijay Karya was also considering a similar issue regarding violation of FEMA. But in Vijay Karya's case, it was held that FEMA could not be said to be something which is the fundamental policy of India, because the defects under FEMA are curable defects. So the question which is really open, and it probably be considered at a subsequent stages, where something is prohibited under Indian law, completely prohibited, and there is no cure to it. An award which directs you to do something or pay damages for not doing something which is prohibited by Indian law, can it be said to be contrary to the fundamental policy of India? This requires a further, probably NAFED says so. And it would require, and Vijay Karya does not on a factual basis deal with such a contention. So it requires further development, and probably the law will develop, but often the law also develops depending upon the facts of the case. So we'll have to wait and see.
Maybe Supreme Court will consider this issue in some matter somewhere. Before I jump into the questions of the audience, any concluding remarks? 20 seconds, 30 seconds each to each panelist. Nick, anything?
Nothing. I look forward to the questions. Thank you.
Sanjeev?
Nothing, Raj. Only one comment is that if we look at the evolution of the arbitration, I think, and look at the judgments, we would see that regime is becoming, whether it's legislation or interpretation of the by courts, it's becoming more and more pro-arbitration.
Vivek?
Yeah, just one last thought to repeat what I said earlier. Don't neglect enforcement. It's as important as it is getting an award. And that would be my
Gaurav?
I think I would agree with Vivek that, and also with what you said, that if you're a potential claimant or you're the claimant, don't neglect the enforcement and plan from day one. Probably plan during the drafting of the agreement. If you think that there's a potential case which would be likely to come up where you may have disputes and you may have a claim. But definitely once the arbitration commences, please plan in advance and ensure that technical grounds are not available to challenge the award. Because the moment technical grounds become available, it does take time, as Nicholas correctly pointed out. Ultimately, the decision will be in your favor if you're correct. Indian courts are very good insofar as merits of the case are concerned, but it does take time. And the process takes time. And then it can be a bit frustrating for a foreign party who finds that it's taken a few years to enforce the award, when they expect that enforcement should be done in a few days at a very limited cost.
So there are quite a few questions that we have from the audience, and maybe I will pick up some of them. Some of them, including there's one from Sunita Advani, and a similar question by a couple of others, to say what steps is India taking to reduce the backlog in the courts in India, and what is the step the governments are taking to bring in efficiency, to increase efficiency for enforcement of, so that the enforcement process can go ahead faster. Sanjeev, Gaurav, one of you.
Well, as far as the legislature is concerned, acts are passed, Commercial Courts Act has been passed. But on ground, if you just don't have adequate judges, you have huge vacancies. Appointment of judges is a time-consuming process, particularly to the High Court and the Supreme Court. And you have so much litigation in our country. Ultimately, even judges are human beings. There's a limited number of matters they can deal with. If you look at a board of a judge on a given day, he'll have 50 matters, 100 matters. If you expect any human being to dispose of so many matters in a day, it's just not possible, humanly possible. So, yes, basically the number of judges has to be increased. And that unfortunately is time consuming, and despite various time limits being brought in by various acts, you find that ultimately a view is taken that those are not mandatory, but they are directory, because it's just not practically possible to dispose of. So even if you bring in a legislation saying that enforcement should be disposed of in 6 months, 3 months, it's just not practically possible. And if you end up with a COVID-like situation, of course, it's going to become even more difficult. So
there's a very interesting question that has come from Akriti Kataria. I understand that limitation period for enforcement of a foreign award is 3 years, while the limitation period for enforcement of a domestic award is 12 years. Is this fair in your opinion? Sanjeev?
I think it's Justice Indu Malhotra's recent judgment wherein they considered it, and then they kind of found out that and held that essentially a foreign award is on a different kind of a pedestal, and it's not a decree of the court in that particular sense. And if it's not a decree of the court, then obviously you go under Section 137 of the Limitation Act and not 136, which is 12 years, and 137, which is 3 years. So essentially, I think there is a and if you have time, please go through that particular judgment. I think it's very, very well articulated judgment. So I think there is a cause which has been clearly articulated as far as that particular judgment is concerned, and bringing in that kind of a distinction. And for me, I would say always that there should always be a limited time for you to enforce an award, because obviously you want uncertainty in a commercial relationship or in a commercial transaction, and you can't just keep it on lingering for a period of so many years. So if it has happened in the case of an international award, I would say that that's a good beginning.
There is one more question that's again an interesting question. Are awards under bilateral investment treaty enforceable under the New York Convention in India? Sanjeev, would you want to take that?
So I would say that New York Convention is where the seat of the arbitration is. It's not whether an award is under a bilateral investment treaty or a institutional arbitration or a arbitration which is ad hoc, which is seated out there. So any award which is passed in a country which is which is a reciprocating territory under New York Convention would be enforceable.
There is one question coming from arising from the YMCIA judgment, which is, do you see Indian courts making use of residual discretions in the refusing enforcement as indicated in YMCIA's judgment? Gaurav, any thoughts?
Residual discretion is, I think YMCIA's judgment is very clear on the grounds that certain grounds are mandatory, certain grounds you can, you have a discretion. Even if the ground is applicable, you still have the discretion to enforce the award. That's what YMCIA's judgment says. So when they talk about residual discretion, I don't know in respect of which ground whoever the questioner who's raised the question is referring to. But the discretion is generally to enforce the award, notwithstanding the fact that, broadly speaking, one ground is made out because the court finds that no prejudice is caused to the party. So I think courts, and it does say that these are watertight grounds. So there's no question of having grounds other than the ones which are there in the Section 48.
One more interesting question is, if an arbitral award has been passed on the basis of an unsigned arbitration agreement, can the same be challenged under Section 48 during enforcement?
And you have to go back to 48 and see the principal grounds. One of the grounds being that there is no arbitration agreement. So yes, you could probably say that the award, in the absence of an arbitration agreement, there was no arbitration agreement, and therefore, jurisdictionally speaking, the arbitrator had no jurisdiction. But I think that would more depend upon the applicability of the foreign law, because you would not be applying the principles of Indian law and what constitutes an arbitration agreement under Indian law. While seeking enforcement, if the foreign law permits even an unsigned document to be recognized as an arbitration agreement, subject to whatever limitations are there under that law, then Indian courts would enforce it. In fact, we had a situation like that, where an unsigned document and document exchanged by correspondence were standard forms of contracts, and they've been enforced in India, such awards. So it depends upon the law and whether the arbitrator, point was raised before the arbitrator, and what is the finding of the arbitrator. If he holds that under foreign law, it's an enforceable contract, I don't see any reason why the Indian courts would not enforce it.
Thank you, gentlemen, for your elucidated views and thoughts on issues, especially concerning those who have obtained an award but are still waiting to enforce them in India. and the challenges that they may probably face or they should keep in mind. I think it's an important takeaway for them. I think for me, it is very, very important to see that when you need to give a lot of importance to your enforcement proceedings and think about enforcement from the drafting stage to the arbitration commencement stage to the execution stage. I think it's the most important part, and that's what you want to eventually achieve if you're going into arbitration. Because even if you succeed, you need to still enforce them. It's also been a lot of interesting thoughts that we've got on the emergency arbitration award and how they can emergency arbitrators play out their awards, whether they are tribunal or not. So I think these were very interesting points that we discussed today, and I think I'm sure for the participants have taken something from us today. I thank you all the panelists for taking your time today and giving and sharing your valuable time and thoughts on such an interesting topic on enforcement of awards in India. I also thank MCIA and India Arbitration, India ADR Week for organizing this India ADR Week, and we are quite proud and happy to be part of it. Thank you, MCIA, for hosting us, allowing us to host this session as well. Of course, we will try and attempt to answer all those questions which have been posed, but we could not answer it right now. We will try and send a response to you in writing as far as possible. Thank you, everybody, for joining this session in today. Thank you.
Thank you very much.
Thank you.
Thank you all the panelists. It was a brilliant and informative session with your practical experience. All of you together made the session so lively. Gaurav, you succinctly described the restricted grounds of resisting enforcement. Yes, these are watertight grounds under Section 48. Sanjeev's suggestion on filing the enforcement in India were very helpful. Nicholas, your inputs on emergency arbitration award rather order were very informative. So did yours, Sanjeev and Vivek. Enforcement is a stage where you reap the benefits of your success. So don't neglect this stage. Thank you, Raj, for moderating this session. Your precise questions really shaped the session, in fact. So that concludes the session. The next session is today at 6 p.m. IST. The topic is forum selection after Brexit, anti-suit or anti-arbitration. So another thrilling session is awaiting. Friends, please tune in for it. Thank you all, those who are watching, for joining us for this session. Thank you.